Welcome to Guardians of Innovation, Patent and Trademark Law.
Hello, everyone. Welcome back to Guardians of Innovation with Vincent LoTempio. Hi, Vincent. Welcome.
Hey, it's nice to be here again. I always enjoy working with you.
Awesome. Vincent is a registered patent attorney with more than 25 years of experience helping inventors and entrepreneurs protect and profit from their ideas. I'm Sean O'Connor, and today we're covering what to do before you share your idea with an investor or a manufacturer. And these conversations can open big doors, but they can also carry risks if you're not prepared. And that's why we're calling it Protect It Before You Pitch. Vincent, why is it so important for investors to protect their ideas before talking to investors or manufacturers?
I always tell people, let's fix it beforehand. It's always easy to fix it ahead of time than afterwards. And a lot of times you can't fix it afterwards. People come to me and say, I try to do it myself. And I said, if I was a builder of a house and I was the general contractor, you said, could you come and fix it because I started it? And you had the roof in the basement. I'd have to say, well, this thing can't even be fixed, and sometimes it can't be fixed. So you want to have your game plan, your architectural plans up front and ready to go, and not try to fix it as you go. And the number one thing is with patents is that you keep it secret. You don't let it out of the bag, because the basic rules for patent law is the first to get to the patent office wins the race. And if your idea is out there and somebody else files it before you because you gave up that information, well, that's going to be a problem. There's a lot of issues that we clear up ahead of time, but first is keeping it private and making sure we're the first to file.
So, yeah, that makes sense. But what can happen? Let's say an inventor discloses too much without the right protections in place. What are the ramifications of that?
So the first rule is that, and this is a US rule, and I file patents all over the world, but we focus primarily in the US, is that if you offer it for sale, you use it in public, or you publish it anywhere, you have 1 year to file your patent application. So, that's one rule. So you have a year to file it. So say you offer it for sale and then you file your application over a year later, you'll lose your patent. You won't even, you'll lose the patent because of that. The other thing is the other rule is that you have to be the first to file. Now, you have to be the first inventor to file. Now, if somebody else takes your idea and you can prove that they took it from you and they really didn't invent it, you could win that. It's called a derivation proceeding. They derived it from you. But, if you have it out there in public and somebody does that, how do you prove that they got it from you and you had it first? There used to be a thing, they'd call it the poor man's patent, where you could, and I just got a phone call the other day that somebody said, yeah, I put it in a registered mail and I sent it to myself,
Yeah,
to prove it.
I've
Well,
heard
you
of
can
that.
prove that you invented it then, but you can't prove that they got it from you. So the rule changed in 2013 to be the first to file, not the first to invent. Before that, it was just if you can prove you invented it first, you'd be okay. So
Hmm.
so that's the key. I mean, and that's why when you're working with manufacturers or you're working with potential partners, you got to have in place agreements, non-disclosure agreements, and you got to really race to get that patent filed as soon as possible.
Well, what about provisional patents? What is the provisional patent about?
So there's really no such thing as a provisional patent, and that's a misnomer that a lot of people call me and say, I want to get a provisional patent. There's a provisional patent application, because a provisional patent application never becomes a patent.
Hmm.
It simply sets a date to prove that you got your filing date. Because remember, we said it's a race to the patent office. So
Mhm.
as soon as you file your provisional patent application, then anything that happens after that won't affect your application. But you have 1 year from the time that you file your provisional to file the non-provisional real patent application. So the reason this is in effect is to help independent inventors compete with the big companies, the
Mhm.
IBMs of the world that filed thousands and thousands of patent applications, and they can afford to do that. But patents are very expensive, and I'm probably in the middle range, the lower range of how much it costs to file a patent. But if you go to some big firms, they'll charge you $20,000, $30,000 to file a patent. I'm closer to the $10,000 range. But at the end of the day, if you want to file 10 patents for $10,000, who has $100,000 to throw around? Even
Yeah.
has $10,000. Could you loan me $10,000, Sean? You know, it's a big chunk out of your bank book, right? And you want, you want to be able to compete with these big time, companies. So a provisional application is a lot less expensive to file because it
Ah,
doesn't have all the requirements of the non-provisional. You don't need formal drawings, you don't need a background, you don't need claims. You just have to have enough in there to prove that you had the idea on that date. So you can file it for a lot less money, and it gives you a year, like we said, a year to file the non-provisional. In that year, you got to go out there. You have to have the fire in your belly, the fire under your feet to go out there and see if this is going to make any money. At the end of the day, you're looking at your return of your investment. How do we make money on this thing? And so it gives you a year to go out there and see without worrying that somebody else is going to beat you to the patent office and take your idea from you.
yeah.
But I always say you really don't have a year. You can't call me on the 364th day and say file this today. So you really gotta start going once you file that provisional patent application.
Got it. Got it. You mentioned NDAs, which most people know, non-disclosure agreements. Are there scenarios where an NDA isn't enough to fully protect an invention?
Well, I always say an NDA is a modicum of protection. It's not foolproof. The only thing that's foolproof is the patent itself, right? I mean, I have an NDA with you, Sean. Don't tell anybody about my new idea.
Right.
And then you tell your sister-in-law's brother's cousin, and he tells it to his garbage man. And next thing, his garbage man is making this thing. How do we connect it up? How do we have that nexus between you and this garbage man out in Tippecanoe?
Mhm.
How do we do that, right? So if that company that you have that agreement goes out and does it, yeah, I mean, we can prove it in a contract that we showed them the idea and then they stole it. But at the end of the day, it's just limited. It's a deterrent, but it's not the end all be all.
Got it. Got it. Now, I'm guessing, I mean, given your experience, you've seen mistakes, common mistakes that get made. Um, I don't know, inventors are pitching too early without the right protections. What are the big mistakes that they need to look out for?
Well, that's the thing. I write blog posts and I do these podcasts. I should do them more often than not, but I've been doing it for, you said at the beginning, more than 25 years. Now it's 2026. I should start saying more than 26 years.
Mhm.
But yeah, I mean, at the end of the day, people, they the big mistakes are just not filing it timely and getting it timely, doing the search and doing the research and getting it done quickly. And I think that's always the biggest mistake is coming late. I get people on the phone. I've been doing this great thing for 3 years. I want to get a patent on it now. Well, it's too late now. It's the first thing I say, and I say, well, when you first did it, was it an experimental use? Was it? We try to work the facts to the point where, is this something we can get a patent on? Is it something that you've invented recently and not 3 years ago, even though you've been using it for 3 years? So I think the big step is, before it gets out there in public, is to have something filed.
You'd mentioned, well, I mean, a lot of this is around going out and trying to spark interest, see if it's going to be a profitable idea. How do you, as an inventor, how do you share enough to spark interest, but not give away too much as to expose yourself to potential issues?
Well, that's always a fine line. And I wrote another podcast about fundraising. What's you put it out, Kickstarter.
Oh yeah,
So
yeah.
Kickstarter, you're just starting, you don't have it, and you're looking to see if people like the idea. So the question is, did you put enough information in there to get people to bite, and yet not enough to really tell them what your invention is, where they can copy you? So that's always a fine line, and that's where you might think about filing provisionals. And the big firms and the big companies that have a lot of money to do this will file multiple provisionals as they go along.
Mm.
And sometimes you'll put a lot of stuff in one provisional, and they call it omnibus provisionals. And the whole idea is what can we pull out of those provisionals to say that we had the idea when we filed the non-provisional. So say
Mm.
you're in the research and development stage and you have this basic idea, and then when you put it together, this one part just doesn't work right. It doesn't work smoothly like you thought it would in your idea. And then it changed a little bit, and you put another part, another structural piece in there to change it. Well, maybe you want to file multiple provisionals to get that new part that wasn't talked about in that first provisional. And those are ways to kind of, I don't want to say jimmy the system, but to work the system to your
Mhm.
favor. You always, people always say you got to follow the rules. Okay, let's follow the rules to their T, and let's use those rules to the best of our ability to do it. And that's, that kind of stuff comes with experience. And I don't know, there's a lot of times, especially earlier in my career, where we would get a patent, and by the time we got the patent, the invention changed so much that it wasn't even, our patent didn't even cover what we were selling anymore. So yeah, there's strategy that goes along with it, and then there's strategy post filing it. There's different ways to work that. There's continuation in parts, re-examinations. Even after you get the patent, you can take the patent and then ask for a re-examination, and then try to get another angle of the patent in the second one and get two or three patents.
Oh,
So there's a lot of ways to do it. And I think, you work with your patent attorney to work out these strategies to give you a robust patent portfolio that can cover all different angles of your invention.
yeah. I mean, it sounds like I mean, I think of a patent and a patent application. I think of it as a thing, an entity, a document, but you're talking about a sort of a system, a strategy that surrounds that and supports that. Super interesting.
Yeah, they call it like they call it like parent child.
Mm.
And sometimes there's a whole family of patents on the first one. They kind of bought off of it and go in all different directions.
Oh,
And sometimes it's difficult for me when we do our patent searches to see if it's out there. We find one of these in the family, and then we realize there's six or seven in the family. And then we look at them, and it's hard to even tell the differences, the minute differences in between each one of them. So yeah, it's a constant, ever moving thing. And then, after, you get your product out there, then you come out with the new and improved product, and maybe that new and improved part is something that's patent worthy. And we just get it on the part of it, on that one part of it. So yeah, and I'm learning more and more as I go. Everybody does, 26 years of how to do these, and you see how people have made mistakes in the past, and then we learn from it. But yeah, that's why you want to have somebody that's experienced, that's done this before, and you're not just going to get one patent. You're going to get a protection over a whole part, a whole
yeah.
genre of this type of thing.
Can you think of an example or a situation where uh, proper protections really, like, saved an inventor's bacon, so to speak? That made all the difference in negotiations. Any scenarios like that?
Well, yeah, I mean, we filed provisional patent applications for people in the past, and I have this one product sitting here on my desk, and it just happens to be sitting here, and he came up with an idea to. This is actually a tube it's like hundreds of yards long, and it connects up to maple trees, and it gets the
Hmm.
maple syrup out of it.
Oh
and
yeah.
and this product, we got the patent for. You can see these wires and everything all over it. He came up with the idea to be able to put this on a special way, this piece, instead of this big black piece in the field, and we'll put it anywhere you want. And these are the extensions where you put your hoses into the reservoir that you're taking the maple syrup to, and from the tree to this
Hmm.
long tube. And uh and basically, he got a, a license and agreement, and he sold the patent to a big huge company, the biggest maple syrup company in Canada. And if he didn't have that provisional patent application filed, and we didn't have control of this idea, he would have never been able to make that deal.
That's interesting. Uh, and yeah, and that image of all the maple trees networked, right? I think seeing that's an interesting process for sure. Uh, what about, for people listening, what's your best advice for an inventor who's getting ready to approach investors or manufacturers, maybe for the first time? What would be your, hey, whatever you do, make sure you do this kind of advice?
Well, the problem is with inventors is that they don't wear all the different hats. In order for you to get your idea out there, you need to, any idea, whatever it is, you have to be able to manufacture it, market it, and distribute it. And everybody thinks that the idea itself is just going to sell it, and there's not too many ideas that are so strong that they sell themselves. I always say, if you have the idea to put peanut butter in the gas tank and you get 50,000 miles to the gallon and you only have to fill your tank up once the first day you bought your car, that would sell itself. But most people's ideas are put this thing in your gas tank, you get a couple more miles to the gallon, and your car, runs smoother and it cleans out the engine and you smell like peanut butter all day long. Those things don't sell themselves. I mean, how many times have you been at a grocery store like a 7-Eleven and it's hanging there and it says put this in your gas tank, and you actually reached out and bought it and put it in your gas
Mm.
tank? I mean, it just doesn't sell itself. So you have to be able to manufacture, market, and distribute. You have to be able to sell the idea. You have to be able to present it to that person. So I think it's more than just the idea. You have to come up with how much money does it cost to manufacture it? What is it? What do you have to do to manufacture this thing? Do you have to come up with new molds or new machines to do it? And when you go to make your presentation to that big company, you have the answers to all these things, because nobody wants to figure it out all from scratch on their own. They want a lot of these things done. I always use the example of when I was a little boy, my mother would sit down with us at the table, and if we had to make a decision on something, we would draw a line down the middle of the yellow pad and put the pluses on one side and the minuses on the other. Now, when you're sitting down at the table with this company or this partner or this guy with the money, the angel investor, the venture capitalist that wants to invest, what do you have on your side? You have the idea. What do they have on their side? The money, the manufacturing, the distribution channel, the marketing ability. They have all these things on their side. You have to take some of those things away from them and put them on your side and try to balance out that sheet so you can make the deal. So, you got to wear all these different hats. And that's the problem with these um, product development companies.
Mm.
They know that you can't do all this stuff, and they know that you, as an independent inventor, are afraid. Just the idea of trying to do all this stuff. So they try to convince you that they're going to do all this stuff for you, and they want money to do it, and then they never do anything for you.
Mm.
So, I mean, and I don't want to, discourage anybody, but you got to understand what you're up against when you're going in there. So you really, I think the advice is to be able to make this presentation and to be able to answer all these questions. And you really have to learn and go to school and figure these things. And I don't mean literally go to school, but you have to be street smart. You got to be smart and understand that these product development companies are just going to rip you off, and you got to stay away from them. You got
Mhm.
to be book smart. You got to know, what does it cost for the materials to make it? How much does it cost to ship it? Where do you get it? How do you manufacture it? Who's going to be your target audience? How are you going to do these things? You got to learn those things, how to do it, even if it's just a couple of hours a day of being on the computer and talking to people and learning how to do it. And then you have to network. You have to talk to as many different people as you can. And that's the same advice I give to the young hockey players that I coach. I coach the high school team and the grammar school modified team. And I say, look, you have to be book smart, street smart, and networking in life. Those are the key things that you need to be.
Yeah. Yeah. I mean, it's great advice. We think of inventors being a single entity, but obviously to have whether it's a virtual team or a plan. I mean, even just some of the questions you were rattling off there, it's like, oh, okay, you need to be ready to address those concerns on the pros and cons list. So great stuff.
Yeah, you can't walk into that meeting and say, "You guys figure all this stuff out for me. I got the idea. I'm done." It just doesn't work that way.
Yeah, no, well, great stuff, Vincent. As always, uh, thanks for this conversation. I know we've got future conversations that I look forward to. You have a great day, and
Yeah, thank you. Yeah, I always wonder what can we talk about next, but somehow, some way, we just walk through these things. This is great. I really appreciate your help.
thanks for joining us on Guardians of Innovation with Vincent LoTempio. If you're preparing to share your ideas and want to make sure it's protected, Vincent and his team can guide you through patents, NDAs, and the best strategies for keeping control of your invention. Visit lotempiolaw.com to learn more. And if today's episode helped you, don't forget to like, leave a review, and subscribe so you don't miss any future episodes. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.